welcome
Hello.
to another edition of Thinking Like a Lawyer. I'm Joe Patrice. Missing her cue there was Catherine Rubino.
I wasn't missing it.
I
mean, I think it was correct.
I
think it interrupted you, which is pretty much the point.
yeah, I
So,
guess.
Mission accomplished.
We're along with, as always, Chris Williams. We're here from Above the Law, and we're going to talk about some of the big stories of last week, which in this instance was a lot of them, because it seemed like last week was when everything happened, like all at once, and none of it was particularly good,
Well, that's great. Hopefully people had good weekends regardless.
That's the signal for the beginning of small talk, which is
that was revenge. That was revenge. Is what it was.
That was the awkward part where we talk about just anything. So what's up?
Chris, did you have a good weekend?
I had a really good weekend. I stayed in the house, did a lot of sleeping. It was really productive. Some of the productivity moved into today. I got help from a friend to throw a couch out from my living room that may or may not have had fleas. Anyway.
Oh, well, that's not great.
It is not that it was there, but it's great that it's gone.
Sure. It's all about perspective.
Yeah. And there will hopefully be less perspective with less living things in the house, because those bastards would not die. Also got a new phone. It's my second phone. I have a work phone now, because I was like, I'm at that phase in adulthood where I should probably be separating my work persona and my persona.
Mm.
And the reason it happened, some inside baseball, is because I was using my personal phone to do all the tweets and the what have you, use my Facebook, but also post things to ATL's Instagram, which everybody should be following. I saw a hilarious video. I needed to share it. I did share it. It was not legally related. I shared it to the legally related Instagram. Immediately deleted it. Hopefully nobody saw it. I can't have that happen again. So I now have a Pixel 3a.
Fair enough. And Joe, I believe it was your birthday this weekend.
It was. That's
How's
true.
getting older working out for you?
Super.
Taking it one day at a time.
So far, 29 doesn't feel any different.
Oh.
So that's great.
You celebrate, though?
Yeah, I did not do any sleeping. I partied like crazy, that sort of thing. As usual, as one would.
As per usual. Well, that's good.
That's great. Are we done with small talk now?
I guess with that kind of scintillating response to you had a birthday weekend. You're like, yeah, it was great.
What about you? Did you do anything?
I mean, I have a personal phone to separate my business. Is the theme here.
Amazing. We do have kind of a jam-packed legal story week, so I guess we can.
So we should probably.
You did that on purpose.
Mm-hmm. Call off small talk there a little bit early. So there's a lot going on. I don't even know where anybody wants to start with this bonkers week
Dealer's
that was.
choice, my friend.
Chris, why don't you tell us what's going on with Marjorie Taylor Greene? She had a bit of a hearing the other day.
Yes. I'm glad this was one of those things that was added to the Constitution. 14th is a bit late, but there's a provision that's basically like, hey, if you do things that are like treason-esque, you probably shouldn't be in office anymore. And looking at the history of things that Greene has done and that have been like highly circulated on Twitter and the YouTubes that you can go see, she probably did some treason adjacent things. So there's a trial going on trying to prevent her name from being on the ballot, because clearly the things she's done have been good for people voting for her. Looks like the only solution would be for her name to not be on the bill. So that's been going on.
Yeah, I mean, the 14th Amendment might be a little late to put that in, but it was the most relevant time since they had just, had a bunch of treason going on.
Fair.
What with the Civil War and all.
I mean, so far from the bits of this hearing that I managed to watch, it was some truly incredible stuff. The judge seemed very unhappy to be there.
I think that that's the right reaction.
She had some responses that were ultimately required some intervention from the judge, responding to questions. Did you send X tweet with, well, and beginning a long story that is
yes
not
or no
the answer.
question.
Yeah, that is not the answer, yes or no. So with that, so she did that. She had to be informed. Well, did you do all this? And and like the cagey answers that like everyone assumes are lawyer answers, but in many ways are what lawyers tell people not to do because it makes you look like garbage on a videotaped hearing. Answers like, well, according to this news report, I said those things. It's like, well, come on. Did you or did you not? Like that kind of caginess. It's not like a memo an email that you wrote from 9 years ago. This is something that you said publicly and repeated a lot a year ago.
And also this goes to the point that Marjorie is not an attorney, right? And I think that at best she has watched a couple of episodes of some, legal procedurals, not even the good ones, like the crappy ones. And that appears to be how she's getting most of her tips and tricks of how to deal with an actual trial.
It gave a lot of, it depends on what is.
Yeah, real is energy, right?
Right. And we're literally still talking about that terrible answer, 3 decades later. So maybe that wasn't the play. It's just not the play.
Well, that would be a thing you would want to remember. But considering how often she forgot on the stand, I wouldn't be surprised this is how the things played out. I think at one point, I would not have been surprised if they asked her name. And she was like, I don't know. I've been called Susan on occasion. Like...
Now, see, how did you miss that? She's been called Karen on occasion. Is the actual answer to that?
That was a
missed opportunity.
I guess I didn't care to make it.
Penalties.
Ooh, you suck.
Yeah. That's a new one.
Just to be clear, that was not a sound effect. That was the ghost of somebody relevant. They just wanted to share their thoughts.
I've been adding some sound effects. I feel like that it was time.
You proud of yourself there?
Yeah, I am.
Oh, good.
Yeah.
That one,
good.
I will say something that might not have been said often enough on the podcast. Joe Patrice, that was good.
Thank you, everybody. Thank you, everyone. So I'm going to use this to transition to another quasi story that's going on that we didn't even plan on, but your conversations about how Marjorie Taylor Greene is not an attorney, and that's why some of these mistakes happen. Someone else who isn't an attorney is Johnny Depp, who seems to have figured out how hearsay goes better than most second-year law students. For anyone who's not following that story, Johnny Depp and Amber Heard are in a lawsuit, and on the stand there were some questions, and Johnny was aware enough to wait for the hearsay objection. He was like, I'm pretty sure that's hearsay. It seems like he's learning. Johnny
Depp, better attorney than Marjorie Taylor Greene. I had that on my 2022 bingo card, so winner.
There's like a Pirates of the Caribbean savvy joke here.
That
needs to be made. Maybe he got like consultation from Davy Jones or something.
I was going to make
Davy Jones Day.
No, I was going to say that a lot of people think that he's learning on the fly, but I think he's always understood this from Jump Street.
Oh,
yeah. See?
You
there
suck.
You go. No, that is not what that sound effect was. That is not a place for that sound effect.
Damn it. See, this is why you don't feed the Joe. You feed the Joe one little compliment.
Hey, you know what else is going on?
What else is going on?
Phone. Oh,
you should get that, Joe. Pick it up.
Well, we don't have time to get that right now, but that's why we work with Posh, whose virtual receptionist can handle that for us and allow us to keep on the work that we're doing. So let's hear from them.
As a lawyer, ever wish you could be in 2 places at once? You could take a call when you're in court, capture a lead during a meeting. That's where Posh comes in. We're live virtual receptionists who answer and transfer your calls so you never miss an opportunity. And the Posh app lets you control when your receptionist steps in. So if you can't answer, Posh can. And if you've got it, Posh is just a tap away. With Posh, you can save as much as 40% off your current service provider's rates. Start your free trial today at posh.com.
All right. So, hey, there's no mask mandate anymore. That's a thing.
Yes.
So there was a opinion handed down from Catherine Mizell, who you all may remember as the Jones
Wildly
Day
unqualified.
that Jones Day associate who managed to get a seat on the federal bench after Trump had already lost his election, but before Biden had taken over. She managed to get herself confirmed, even though she's only a year removed from being a clerk herself. She decided to issue a nationwide injunction removing the mask mandate, which, well, what do you want to say?
Here's the thing.
Yeah.
It's not about the mask mandate per se. There's a good argument that says that the Biden administration probably should have rescinded the mask mandate prior to the decision. I don't want to get in the weeds about whether or not people should be wearing masks on a plane. Let's just put a pin in that question. Sure. But let's just put a pin in that question, because the actual problem, I think, is the quality or lack thereof of that opinion. Because by looking at that decision, I would say she was probably not a great clerk.
Yeah, well, I mean, Thomas.
That's her only
Thomas.
experience.
It's not like you have to actually be all that good. Blah blah blah. We're making up something about Blackstone's commentaries. Anyway, but no, it is a problematic decision, and it also puts the administration in a bad position where they have to appeal it to fight it because of the reasoning of it, even though I think most people do think that the mandate had outlived its usefulness at this point. But now, because of the way in which she struck it down, they're in this position. Oh, well,
do you want to go into some of the details about sort of the terrible reasoning that's involved?
Do I ever? So the statute actually says, so for the purposes of carrying out and enforcing such regulations, that the Centers for Disease Control can provide for such inspection, fumigation, disinfection, sanitation, pest extermination, destruction of animals or articles found to be infected or contaminated as to be sources of dangerous infection to human beings, and any other measures as in his judgment may be necessary. That's what the statute provides. Whether or not the mask mandate was still a good idea or not is something that's within the CDC's discretion. Courts can't really get rid of that. That said, she did. And because she inserted courts into the discussion, she had to find an angle for that. And the only angle is to basically say that the CDC doesn't have the power ever to have done this. And that's what puts the administration in a bad spot, because even if they would be willing to let the mask mandate go, they now have to keep it so that it's not moot when they have to challenge this, because it's really problematic if the CDC is not legally allowed to have public health measures. Her reasoning for this was that the word sanitation, which she determined was the only word that could have justified a mask mandate, put aside the word and other measures.
That seems like a pretty big thing to put a pin in.
It is. I mean, there's questions with whether or not you count things like that, but to be like, you don't want a situation where like broad power is just completely broad. It has to be somewhat related, but it seems like this would be somewhat related to sanitation. But also, sanitation seems to cover masks that prevent infections. However, she argued that because other words like disinfection are in there, it can't possibly mean that. And according to some 1943 dictionary she found, sanitation can mean to keep things clean, but it could also only mean to clean things up after they've already been made a mess of. And her reasoning is that that's what people at the time must have thought it meant. And so the CDC is not allowed to have any regulations to prevent the spread of a disease, but only to go around cleaning up diseases after they've been spread.
I mean, that's terrible.
Well, it would make pretty much no sense, right? Especially for a law that was put into place to allow the federal government to fight TB. It seems as though a pretty clear historical reasoning behind it is for them to pull people aside and have sanitary conditions and put people in masks, etc. And
I mean, I think we all we obviously have lived through a pandemic at this point, and as bad as, COVID is, imagine a disease that has a higher death rate, something like Ebola, right? Mm-hmm. If the CDC can't do things to prevent the spread of Ebola, query, why we have a CDC?
Yeah, and this reasoning, as shoddy as it is now, sits out there, and so they have to appeal it, and they can't remove their position on the masks, or else it would be moot. And
Correct.
so now we're stuck in this world where they're going to keep saying that we need to have masks. Obviously, it's not in effect at this point because of the appeal, but they're going to have to fight and win an argument that the mask mandate has to come back and then turn around and get rid of it. It's a farce that only is happening because courts have decided that they're going to be the ones to make laws.
Which historically was the opposite of what conservatives
Laws are for.
Also specifically that the Republicans used to say, right? There was a time when they said that the opposite should be true, that judges should not make laws. And the slow sort of being frogs in boiling water changes in the conservative position on what the judiciary can and cannot do is now fully complete.
Now who's outing themselves as someone who's getting older? There was a time when they believed that. Oof.
Or just somebody who's aware of history. Either way,
You can both be old. My takeaway from this, the young one talking here is I love that the way this is going to play out is while this is happening and you don't have to wear a mask, the COVID numbers are going to go up. Mm-hmm. And then right-wing folks are going to be like, see, the vaccines aren't working. So if you get the masks, people complain about liberty interests not being recognized. And if there's a suspension in mask use, when the effects happen, like I think it was American or Delta, it was some airline, like immediately after this happened, they noticed the numbers of stewardesses, what have you, they got infections. We're like, well, you should have seen this coming, but now it's going to be a fault of the trying to help people not die.
Yeah, it's not so not great. A really problematic for those of us who are statutory construction nerds. It was a lot of fun just to read how badly that can go. It was textualism ad absurdum, I think is how I put it. Just like the idea that, well, we're going to say sanitation. I mean, she said her 1943-ish or whatever year dictionary had both definitions, and then she just concluded, but obviously, since there are two different definitions, these contradict. They don't. And so we have to choose one for no reason. And she just chose the one that happened to not include...
It supported her results.
To not include the mask mandate. But this brings us all the way back to the and other measures thing, which even if you don't want to believe it's broad-based and can do everything, if there's at least two definitions of this word, you would think at least the alternative one would fit under that. But now it doesn't even get there. Like, just really problematic. And this is, given that this is somebody who is an associate, we're looking at somebody who could easily still be issuing opinions in like 2080.
Oh.
I want you to recognize that that's a thing that could easily happen here.
I mean, Joe, let's be realistic. It's not like we're in a climate where people obsess over the skill of recently appointed judges or anything. Like, imagine this would be a problem for anybody. Anybody can just interpret however they want without any consequences, especially on like a public scale.
Well, and it's interesting about skill. This transitions well to Catherine. There is a Supreme Court justice whose credentials are beyond reproach, and she seems to be a little tired of her colleagues.
Little testy. Elena Kagan, who, let's also remember, famously Scalia supported her appointment to the bench, even though their politics are very much, or were, because he's dead, in opposition, because he's like, if you're going to give me a liberal, at least give me a smart liberal, right? And that was the position on Elena Kagan, but she has had it. She is in the recent Brown v. Davenport decision, which is a habeas case. The majority went on a long explanation of history, and as she said, neither the parties to this small and legally mundane case thought it a suitable occasion to hear from a Blackstone onward theory of habeas practice. Yet the majority, unprompted, embarks on that project, perhaps hoping that the seeds it sows now will yield more succulent fruit in cases to come. She's over it. Hashtag over it. And the notable part is that Kagan historically has been the liberal or the democratically appointed justice to go out of her way to kind of reach across the aisle and try to get her conservative colleagues on board with a lot of cases, and she's over it. She's calling them out. She's saying, this is bullshit. I'm done. Well,
I'll push back on that. I'm not sure she's calling them out as much as she's calling Neil Gorsuch out. I feel as though we also had just had the shadow docket opinion where she managed to get Roberts on
Sure,
board.
I do think that she might be a Roberts whisperer, where and we wrote about that at the time too. That the language that she chose to use in that shadow DACA case, she didn't use the term shadow DACA, for example,
instance,
which John Roberts has some thoughts about. So I do think she may be a bit of a Roberts whisperer. But again, I think that Roberts is certainly the center of the court at this point, which is horrifying, but certainly the far right of the court, I think she's lost her patience with a lot of them,
especially Gorsuch, who comes across as though he's a weird true believer. Like, he believes the crazy stuff hook, line, and sinker, which sometimes works to our benefit. This is why he's the one who crossed over the aisle. It was like, yeah, you can't discriminate against LGBTQ people because, it just says on the basis of sex here. So sometimes that works. He also wrote a pretty good, at least rhetorically useful opinion about the problems with the way in which the U.S. relationship with Puerto Rico is structured. He's had some good opinions in the past on indigenous rights from his days out in Colorado. Like, he's kind of a loose cannon. I think the way in which there's not a cohesive judicial philosophy there, other than whatever the craziest thing in front of him is why Kagan has lost her patience, because there's just no reasoning with him.
But it's also not just Gorsuch, right? Not just because other people signed on to his opinion in that particular case, but we record this a couple of days before it gets published. But there was a hearing today in the school prayer case, and Kagan got into it with Kavanaugh, right? And, I again, it was a kind of a snippy exchange and not something I think you typically associate with Elena Kagan. And here we are again with her kind of taking that more pointed tone.
Yeah, but we'll probably have to talk about this more next week, because the argument will actually be done. But yes,
sure.
The school prayer case, where they're trying to bring back school prayer, which they inevitably will because they have enough votes to do that. There was a exchange where Kavanaugh tried to write it off as, well, of course we should allow teachers to force their students to pray. It's no different than if somebody showed up on Ash Wednesday with ashes on their forehead. And Kagan's like, but that doesn't require people to participate, which is somewhat of the problem. But yeah, we'll deal with that a little bit later. Also, while we're talking Supreme Court stuff, I guess I'll throw in the Supreme Court seems to be going for Miranda rights. You may remember those from every cop show you've ever watched.
Even the good procedurals.
Yeah, and you have the right to remain silent, but not so much anymore. The Supreme Court seems to be very eager to attack this, and the Biden Justice Department is ready and willing to help the Supreme Court strike it down. They wrote an amicus brief in which they took the position that Miranda should be treated as an evidence exclusionary rule, as in, well, yeah, you got to coerce a confession without giving, Miranda warnings. You can hash that out, and if they get acquitted anyway, no harm, no foul. This is how they handle search and seizure stuff. Obviously, there's never been a case where cops have illegally seized anything, and that's resulted in a conviction.
Thank God.
Yeah, because that does happen, because the way it works when you have an evidence exclusion rule is they balance stuff and they end up saying, yeah, they did this illegally, but we're still going to allow this conviction to work. The issue is the Miranda rights are supposed to be self-executing. By the Constitution, you cannot testify against yourself. And if a coerced confession is being brought into the case, you are testifying against yourself, against your will. And that is why it is a no-no that is not subject to balancing. It is itself the problem, which is what the briefs for the person bringing the case say. I know. Dean
Is that how they taught it in
on that.
school? Was there some old guy that called it a no-no and you
I mean,
judiciously wrote it down in your notes?
I can't even remember how that was handled. I actually don't even know as though that was handled in law school, because, again, this is something that you know from having watched Law and Order at any point in your life. And like, even the shows that are trying to be very very lenient to law enforcement are very quick to say, yeah, you have to give these warnings, because that is how the Constitution works. Instead, we're going to get some opinion that says something like, well, if it was important, then the word Miranda would have been in the Constitution, which, whatever. But something like that is going to be that's how Mizell would probably write this opinion, and Thomas might too. So that's where we are. We have a Democratic administration helping the conservatives take down Miranda, which I'm sure that's going to turn out great. So there we are.
I mean, there's something about reaching across the aisle that's important. Right?
Yeah, So what other horrible things happened last week? I guess I would be remiss without mentioning our top story of the week, which is that Alex Jones continues to make news. He, the right-wing podcaster who called the Sandy Hook shooting a hoax, and that all the parents who lost children there and other family members were all crisis actors. His fans then threatened and attacked those people for years, leading one of them to go into hiding. Ultimately, of course, it was real, and because of that, they sued him for defamation, and those cases are,
Well, there's a default judgment in that case, right?
So he did face ultimately what's called death penalty discovery sanctions, in that he refused to comply with discovery so much that they just entered that. So now all that's up for grabs is what size check he's going to write. There's also a lawsuit happening there's one in Connecticut and one in Texas. This week, what he did was last week, what he did was kind of collaterally attack the situation by going to bankruptcy court and filing in bankruptcy court saying that the entities they're going after are all bankrupt. So we just want them to, they have to accept $150,000 and be done with it, which is a settlement offer that they've already rejected. The reason they're in bankruptcy court, of course, is that it has come out that there's a series of holding companies and related entities, and millions of dollars have been transferred from some of these companies to other ones that are being held by insiders, whether it's him or some family member of his. And this money has been depleted from the folks that are being sued, the entities that are being sued, to these other ones, and now they're claiming bankruptcy. There are laws against fraudulent transfers in bankruptcy. The Bankruptcy Code covers that. I assume we're going to see that litigated out, because you can't avoid your creditors by transferring things fraudulently.
Well, look at the bright side here. Bankruptcy law professors are going to have some great hypotheticals that they can build off of for many years of exams.
That's actually an excellent point.
I think, won't somebody please think of the legal academics?
Yeah, well, and that's a transition, an unfortunate transition, but one final transition we should make as far as things that happened last week. Not as bad in this instance is that Charlie Adelson has been arrested. He was the brother of Wendy Adelson, a former adjunct at Florida State, who was married to Dan Markel, who was murdered by hitmen several years ago. It was never, while the hitmen are in prison, and the person who is the alleged go-between between the hitmen and whoever hired the hitmen is facing trial beginning next week, I believe. Adelson's always been considered the suspect, but nothing has happened in all these years. He was arrested last week because the prosecutors feel they now have the evidence they need, which is technology has advanced to the point where they can audio enhance some conversations that they had, recorded over the years, and they feel that's enough to roll with. So that's happening. This is a story we've been on top of for a while, because it was a real shocking event when it happened, and tragic, and we're
just awful.
Trying to keep up with that. So that brings us to what did anything else happen last week? I think I got everything. I don't know.
That's a lot in a week. It's like seven.
I'm sure there was more
days?
too.
It was brutal.
Like seven of the Queen's days.
Yeah. It was real rough. On those of us who were writing about all this stuff. And we didn't even get into, I think some stuff happened with law firms along the way, and we didn't even get into all that.
That is correct.
Jesus.
Listen.
Yeah, it was rough, but it's a new week now.
Are you okay?
No. No.
Get a good woosah in. It was in the past. Everything will be better now. We can actually trust our democracy and all those things. I'm not gonna lie to you.
LOL.
But
You said trust our democracy? Yeah. So anyway,
That was a classic.
Yeah,
That was
I
a
thought you were
classic.
going to go with the clown sound.
Oh, really? You like that one better?
Well, I mean, trust our democracy.
Yeah, I guess that's fair. All right, yeah. Join us next week, maybe. Well, there will be a show next week. You may not have me because I am doing the next week. I am technically obligated to do our most important civic duty. I will be on jury duty. One assumes that they will find out that I make off-color jokes about lawyers for a living and not be on a jury, but who knows? So I'll have to be there. But then, and then the week after that, I will definitely be gone because I'm at a conference. So this could be the Catherine Chris show for a while now.
One can only hope.
I really need to make sure that you have access to all the sound effects and
So that I can
make it work.
deliberately not use them?
Yeah. Well, right. I mean, obviously.
My
that's what I was
go-to
gonna-
is I can't wait until somebody tries to get me on to do jury duty because I'm just going to tell them that, what is it? I think it's the 9th is the amendment that says that all the people have the rights they had prior to the formation of the union.
Yeah.
I'm going to be like,
prior to the formation.
yeah, or something like that. I'm going to be like, yeah, one of those things is the right to nullify.
Oh, sure. I mean, that's not even that's not even a thing you necessarily need to do. You always technically have that.
No, but like, I'm going to say it. I'm going to be like, the trial is on the 9th. All right, I'm going to be out front of the court on the 8th. Be like, hey, everybody, which is illegal, by the way. Don't do that. Don't tell people they can nullify in the middle of a trial. You can get locked up. That's not legal advice.
So anyway, so there's that. So thanks everybody for listening. You should be subscribed to the show so you get new episodes when they come down. You should give reviews, give stars, write something. It always helps make sure more people know that our show is out there as a legal show. You should be following us on social media. I'm at Joseph Patrice. She's at Catherine1. Chris is at Rights for Rent. Those are our Twitters, which Twitter may not exist after today. I don't know. Elon Musk apparently is buying it.
Elon was last week. It was a heavy week.
Yeah, no. Now
today they're
now they're apparently going to go through with it, according to what just came across. So here we go. So anyway,
Twitter was fun, wasn't it?
Twitter was fun. Anyway, we have an Instagram account apparently. Chris tells me. So there's that now. So what else? Check out the Jabot, a show that she hosts. I'm a panelist on the Legal Tech Week Journalist Roundtable every Friday. You should be reading Above the Law so that you see all these stories and more before we end up having to talk about them here. You should be good people. Be excellent to each other.
Peace out.
No, and thanks to Posh. And I think that's it. All right. Bye.
See you next week.